Choosing cases, choosing justices, factors that justices consider when choosing cases, and factors that presidents consider in selecting Supreme Court justices. So in this video, we are going to do two distinct themes. One, how exactly do you pick a case for review as a Supreme Court? And two, how, as President of the United States, do you decide whom to appoint as a justice to the Supreme Court? So how does the court decide when to take a case? The first thing to observe is the Supreme Court today has full control over its docket, meaning that it does not have to take any case that it doesn't want to review. So if it wants to take a case, it'll take it. It doesn't want to take a case, it will not be reviewed by the Supreme Court. There are several different factors that combine to determine the likelihood of the case being reviewed. The first of these factors is if lower courts decided the case differently. If they did decide it differently, then it increases the chance of that case being reviewed by the Supreme Court. The second factor is if the case has national importance. So if a case pertains to something like a dispute in a presidential election, or if it pertains to an important social issue like abortion or affirmative action, it's more likely to be reviewed by the Supreme Court as opposed to if the nature of controversy in the case were simply trivial. The third factor is if the case addresses an unresolved issue of constitutional law. Sometimes there are issues or definitions or doctrines that are unresolved or very fuzzy, and if that happens to be true in a given case, that case is more likely to be reviewed by the court. And the fourth factor is if the court thinks it can reach a decision. Every once in a while, the court will decline to decide a controversial case because it wants the political process to play itself out, and it doesn't want to get itself involved as an institution in a political controversy. So the lesson here is the more of these factors are present, the more likely the case will be reviewed. Now we go on to consider those factors that determine who will be appointed to the Supreme Court by the President of the United States. No president wants to be embarrassed by his nominee, so the first factor is competence. Incompetent appointments are extremely rare. President will usually pick somebody who understands the ins and outs of federal law very well and of constitutional law in particular. But sometimes you do have appointments that are questionable from the standpoint of expertise. Thus, President George W. Bush appointed his personal attorney, Harriet Miers, to the Supreme Court, but senators actually applied pressure on him to withdraw her candidacy because her answers to a questionnaire revealed that she might not have a solid understanding or as solid understanding of constitutional law as a Supreme Court justice might be expected to have. So Bush actually followed the advice and withdrew Harriet Miers' nomination to the court. So competence indeed is a very important factor. The second factor is ideology/party affiliation. These two are related because they go hand in hand. So presidents will try to nominate someone who shares their ideology, their political views. And how do you decide that? Such a person might have a history of being affiliated with or supporting the views of the political party of the president. So Republican presidents tend to be conservative, and they will appoint conservative justices. And Democratic presidents tend to be liberal, and they will likely nominate liberal justices. So take President Trump as an example. He nominated Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett to the Supreme Court because they are conservative as opposed to liberal. 3 is likelihood of confirmation. Presidents do not want to have a confirmation process that is mired in controversy and that is protracted. They want it to be done quickly, and they want to get an overwhelming vote of support. This has been extremely difficult to actually achieve in recent years, but generally speaking, it has not been too difficult to pick somebody who will get strong bipartisan support. It's only in recent years that the confirmation process became extremely partisan and extremely bitterly divisive. So, how do you go about this as president? How do you nominate somebody who is likely to be confirmed? You need to pick somebody whose temperament is going to be perceived as appropriate for being a judge. So a candidate like this is going to answer questions before the Senate Judiciary Committee from the point of view of impartiality, calm demeanor, and technical expertise, as opposed from the point of view of polemics, rhetoric, or bias. And the candidate will say to pointed questions, he or she will say, Senator, I don't know how I would rule in a case like abortion. I have to see a specific case in front of me, and so on and so forth for every issue that is kind of a curveball, kind of a controversial issue, like gun control or affirmative action. You would have to say, well, it all depends on the case. I do not want to prejudge any case by making general comments, because judges decide cases. They do not establish legislation. You have to give replies in this vein if you want to be confirmed. And generally speaking, this has not been a problem in recent decades. Candidates haven't tried to be contentious. And that's because of the lesson that they have learned in the 1980s when President Reagan appointed Robert Bork to the Supreme Court. And Robert Bork, when he went before the Senate Judiciary Committee, wanted to be controversial. He wanted to be combative, or at least he wanted to have this back and forth between himself and the senators, and to discuss and dispute fine points of constitutional law, which is not what the Senate wants and not what they expect the nominee to do. And so Bork was not confirmed because of his controversial, and more importantly, because of his openly expressed, passionately expressed views. And he failed the test of judicial temperament, so to speak. Had he given more evasive answers, he would have been confirmed. Next one is seeking political support. Seeking political support is when the president is trying to use a nominee as a pawn in advancing his own or his party's re-election prospects. So getting the backing of an important segment of the electorate. Thus, President Ronald Reagan, when he became president, one of his first acts was to appoint the first female to the Supreme Court of the United States. And the reason why that came about is because of the promise that he made in 1980. When he ran for president, his advisors told him of a gender gap between himself and Carter. Women voters tended to prefer Jimmy Carter for re-election. And they told Ronald Reagan, make a promise. If you become president, you would appoint the first woman to the U.S. Supreme Court. Reagan made this promise, and he kept it. It just so happened that there was a vacancy in the very first year of his presidency, and he appointed Sandra Day O'Connor to the Supreme Court of the United States as the first woman. Another example might be Dwight Eisenhower appointing William Brennan to the Supreme Court of the United States, because Brennan was an Irish Catholic, and Eisenhower wanted to secure re-election in 1956. In order to do that, he wanted to make a strong appeal to Irish Americans, many of whom live in the states of New York and Massachusetts, that were crucial to his electoral coalition of states to get reelected. So Eisenhower chose Brennan for that reason. 5 is rewards. In politics, just as in economics, paying your debts is important. Like if you don't pay your debts financially, something bad may happen to you. Like your credit score may be severely damaged, or your possessions may be repossessed, or your house may be foreclosed on. And in politics, if you do not pay your debts, you risk being stabbed in the back. And so if people help you, they usually expect help in return. It's a quid pro quo world that we live in. So even when people explicitly disavow any favors, they often kind of expect quid pro quo. And we even find that in experimental psychology that the best strategy, particularly in interactions that are ongoing, that are continuous, as opposed to one-time or two-time interactions that end quickly. If you have continuous interactions, quid pro quo is the best strategy and is generally strategy that players tend to follow. So an example of rewards would be Dwight Eisenhower appointing Earl Warren Chief Justice of the U.S. Supreme Court in 1953. Why did he do that? Well, because when he ran for president in 1952, Eisenhower needed to win the state of California, and Earl Warren, California's governor, very popular governor at the time, campaigned for him, helped him win California, and as a reward, the next year, Eisenhower appointed him Chief Justice of the U.S. Supreme Court. Next factor is gender. It is now expected that there will be many women to the Supreme Court, on the Supreme Court. President Obama nominated 2 women to the U.S. Supreme Court, Sonia Sotomayor and Elena Kagan. That's a lot, especially when you consider that only 5 women have ever served on the U.S. Supreme Court in all of American history. So 2 of these were appointed by Barack Obama, and as of this recording, both of them are still on the court. There's Sonia Sotomayor and Elena Kagan. As I mentioned minutes ago, the very first woman was Sandra Day O'Connor, and the second woman was Ruth Bader Ginsburg, who recently passed away, and Ginsburg was replaced by another woman, Amy Coney Barrett, who was appointed by President Trump. So what Trump did was replace a woman, Ruth Bader Ginsburg, with another woman, Amy Coney Barrett. Another example is we saw when Sandra Day O'Connor retired and President George W. Bush appointed Samuel Alito to replace her. Alito struggled with confirmation hearings because many senators resented that he was a man taking a woman's spot on the Supreme Court, and Alito developed bitterness against the Senate. Since then, when he walks to the U.S. Supreme Court, he makes sure that he avoids Capitol Hill. So it's kind of interesting that this gender has now become an important factor, really, in considering presidential appointments to the U.S. Supreme Court. Next one is race and ethnicity. Traditionally, the Supreme Court has been an elitist institution, with minorities generally not appointed to the U.S. Supreme Court well into the 20th century, well into the second half of the 20th century. So in 1967, Thurgood Marshall became the first African American to be appointed to the court. And in 1991, upon Marshall's retirement, President George Herbert Walker Bush appointed Clarence Thomas to replace him. There have been a number of other firsts on the court from the point of view of ethnicity or ethnocultural identity. Thus, in 1986, Antonin Scalia became the first Italian American on the Supreme Court. In 2009, Sonia Sotomayor became the first Hispanic on the Supreme Court. In terms of religion, as a point of identity, religion traditionally has not been a major factor in court appointments, but into the 20th century, the court has been dominated overwhelmingly by Protestants. There have been a few Catholics, but not many before the 20th century. But in the 20th century, especially after the first decade of the 20th century, this slowly started to change. And as of this recording, everyone on the court is either Jewish or Catholic in terms of religion. The last factor I want to present is age. In recent decades, age has become a more important factor in appointments. So, appointing presidents want to appoint justices who will serve on the Supreme Court for many decades. For example, President Trump appointed Amy Coney Barrett to the Supreme Court when she was 48 years old. The calculus here is obvious. Presidents want somebody who will be there for decades to come and will perpetuate their ideology throughout that time. Now, the Supreme Court today, Chief Justice is still John Roberts. He is George W. Bush's appointee, by religion Catholic, by gender male. Neil Gorsuch, conservative. He was raised Catholic, although I believe now he attends an evangelical church. Male by gender. Brett Kavanaugh. Like Neil Gorsuch, Brett Kavanaugh is Donald Trump's appointee. He's a conservative and a Catholic and a male. Clarence Thomas is a conservative and a Catholic and a man, and he was appointed by George Herbert Walker Bush. Samuel Alito is a conservative Catholic and a male, and Alito was appointed by George W. Bush. Amy Coney Barrett is a conservative, a Catholic, and she's a woman. She was appointed by Donald Trump. Stephen Breyer is liberal, Jewish, and male, and he was appointed by President Bill Clinton. Elena Kagan, liberal, Jewish, and female, appointed by President Obama. Sonia Sotomayor, liberal, Catholic, and female, appointed by President Barack Obama as well. So that's the breakdown of the court. We have had in recent years 3 new faces, and that's, of course, Gorsuch, Kavanaugh, and Barrett, all appointed by President Trump. Now, Trump got 3 appointments. Both presidents who preceded him, Barack Obama and George W. Bush, they got 2 appointments each. And remember, each of those 2 presidents, Obama and George W. Bush, served 8 years in office. And it just so happened, coincidentally, that both of them only filled 2 vacancies on the court. Donald Trump served 4 years, and in that time, he made 3 appointments to the court, 2 due to death, and when Justice Scalia died, he was replaced by Neil Gorsuch, and when Ruth Bader Ginsburg died, she was replaced by Amy Coney Barrett. And 1 was a replacement due to retirement. When Justice Kennedy retired just weeks before his 82nd birthday, he was replaced by Brett Kavanaugh. The thing here is that the Supreme Court tends to be a very old institution and is like a generation or 2 older than the average age. So the average American is 38 years old. The average age in the court is over 60. And justices tend to be on the older side because, like all federal judges, once appointed, they can serve for life. Nobody has ever been forced out of the Supreme Court through the impeachment process. 1 justice was impeached, Samuel Chase, in all of American history, and he was not removed by the U.S. Senate. After the House impeached him, Chase survived his trial in the Senate and remained on the Supreme Court. The long and the short of it is that these people tend to stay on the court for a very, very long time. There have been exceptions, but generally speaking, once appointed, they'll be there for a long time, and that's why the institution tends to be on the older side.